Then paragraph 152 can be struck out, my lord. We're no longer pursuing that.
Okay.
That evidence that would have been covered by this exhibit. And on that point, my lord, that concludes the leading of the evidence for the state.
Okay.
And we close the state case. It's precisely 3 years since the state started leading evidence, and the state now formally closes its case.
State case closed. Yes.
Balabashishisi lapho lokhuluma phecelezi nodaba lemibukiso ke lokho imibukiso yonkana kade belethile ngaphambi kwenkosi enkantolo ke ukuthi ihamba kanjani list yakhona ke manje bathi baqedile ke ngecala labo ke manje ke ngemuva kweminyaka ke emithathu besolo beqhubeka ke icala labo lokuthi babize ke abofakazi bafike abathi ufakazi babo manje baqedile ke biza abofakazi futhi baqedile ngecala labo.
Yes, Mr. Mnisi.
As it please the court, my lord.
The moment we've all been waiting for has finally arrived. Advocate George Baloyi has officially closed the state's case in the Senzo Meyiwa murder trial. So, what does that mean? Is this the beginning of the end, or just the calm before the real storm begins? In this video, we break down exactly what happens next now that the prosecution has rested. When a prosecutor closes their case, it means they've presented all their witnesses, evidence, and arguments against the accused. In South African law, this is a major turning point. The court now has to ask one fundamental question. Is there enough evidence here for a reasonable court to convict? If the answer is no, then the accused could walk free. Here's where things get interesting. The defense now has a strategic option. They can file for what's called a Section 174 discharge, arguing that the state hasn't proven a case and therefore their clients shouldn't even need to testify. If the judge agrees, some or all of the accused could be discharged right now. But based on the testimony so far and Judge Ratha's posture, that seems unlikely. Assuming there's no discharge, the next step is the defense taking the stage. Each accused can now call witnesses, submit documents or alibis, testify, or choose to remain silent. This is where we'll see counter-narratives, new stories, and possibly bombshells that challenge the state's timeline. Once the defense finishes, the state may get one last shot. They can present rebuttal witnesses, but only if they directly respond to claims made during the defense's case. Then comes the final stretch. Baloyi will make his closing arguments. The defense will argue their case for acquittal, and the judge will eventually deliver a verdict, likely with huge consequences for everyone involved. But here's the twist. The state has closed its case, but new evidence is still surfacing. Before wrapping, Advocate Baloyi re-examined Brigadier Gininda, introduced controversial cell phone photographs possibly linking suspects to the crime, filed subpoenas to extract video footage from ECNCA, hoping to expose Longwe Twala's involvement, and is pursuing AVL vehicle tracking data which could prove that the police's movements were irregular during the arrest of accused individuals. In other words, the real drama is only beginning. So here's what we expect in the coming days. Defense may apply for discharge. If denied, the defense opens their case. The courtroom battles heat up again with witnesses, cross-examinations, and counter-evidence. Then finally, closing arguments and a verdict. But with the way this trial is unfolding, expect surprises, strategies, and delays. The state has played its cards. Now it's the defense's turn, and every move from here could make or break this case. Will justice be served, or is the truth still buried in silence and suspicion? Stick with the Hot Seat essay for bold, unfiltered analysis you won't get anywhere else. Don't forget to like, share, and subscribe, and hit that bell icon so you don't miss the next courtroom twist.
I thought I would have brought the following to the attention of the court even before the state closes this case. Number one, it relates to the video clip of the video clip that Mr. Bailey had to come and give his testimony on. That video clip has already been admitted as evidence before court, and it was on the proviso that Mr. Bailey would come and authenticate it. Now, the court has been told yesterday in no uncertain terms that Mr. Bailey is no longer available to come and testify, and not because he's dead, but because of the agreement that the state and SANEF, South African National Editors Forum, an institution that Mr. Bailey belongs to, that he should no longer come testify because Mr. Bailey and company indicated that if he were to be forced and dragged, come to court, come testify, they'll bring an agent application to bar the state from forcing him to come testify because of the standing agreement between SANEF and the National Prosecuting Authority of South Africa. So as we stand now, or as things stand now, and as at this point in time, that video clip remains unauthenticated. I thought to myself that, and in fact, Mr. Bailey had indicated in an affidavit that was ready to record here, where he says that when this whole thing was taken, when this video was taken, I wasn't party there too, I was in China. So I don't know who took it, when was it taken. I only got requested to provide, as a head, to provide a recording of a video that was aired on the 27th of October 2014, which I did. But as to the finer details and the integrities around that video, I don't know nothing. So if the state proceeds to force me to come testify, I will have no option but to challenge the legality, and that is what the state was avoiding in that agent application. The legality of Section 179 of the Criminal Procedure Act that seeks to deal with the subpoenaing of journalists to come and give information where the state seeks to use the content of their information. But fast forward, my lord, we are saying it's not like all the state avenues have been exhausted. Well, I do not intend to prescribe how should the state proceed with their case or drive their case. But Mr. Longwe is there. If they still want to pursue that video, they can simply say to the defense, no, don't worry, our avenues are not exhausted. Mr. Longwe, who's depicted in that video, is there, he's still alive. He can come himself and authenticate that video. But it seems to me like the state is not amenable to follow that route. So, that video being part of this record, my lord, and not being authenticated as promised by the state in the manner in which it should have no longer be regarded as something that is actually part of the record. I'm not saying that it must be withdrawn. In other words, it's just a pro non scripto. It's regarded as not being existing. That was just point number one, my lord. Now, point number two, on number of occasions, Mr. Sibia has been requesting that certain information, actually the records regarding the movement of the motor vehicles that were used on the day on which he got arrested should be made available to him. I must be honest to the state, they made some endeavors to identify certain motor vehicle. There was a hard body that was involved today. They gave an explanation about the hard body that ultimately was involved in an accident wherein Mr. Mabena passed on. There was a Golf 7. There was also an explanation regarding or around that Golf 7 that it was not fitted with an AVL gadget. There was a hatchback. I think there was also a BMW that was driven by Mr. Buthelezi from Ekurhuleni Metropolis. There was an explanation from Ekurhuleni Police that motor vehicles from Ekurhuleni Police were not fitted then with AVL records. Much against what there's a gentleman used to sit. Much against what Mr. Listering said, that yes, they are indeed fitted. But we're talking in 2020 when Mr. Sibia was arrested. But that's an affidavit that we received from Ekurhuleni Metropolis to the effect that their motor vehicles are not fitted with AVL gadgets. Now, Mr. Sibia keeps on hammering on a Qashqai, a silver Qashqai motor vehicle, and he consistently maintained that it was driven by Mr. Ngamani. Ngamani, I think it's a term of Mr. Masego, but he says they used to call him Ngamani, even the investigating team itself referred to him as Ngamani. We have got no explanation on the request relating to this Qashqai motor vehicle, my lord. And there is also a Ford Ranger that was allegedly also involved when he got arrested. And it was driven by a gentleman known as Bongani Yende. We haven't got an explanation on whether or not we ultimately received the AVL records relating to this model VI case, my lord. May I again confirm with Mr. Sibiya if there's something that I'm missing, my lord, so that I also place it on record, my lord. Thank you. Thank you, my lord, for the indulgence. Yes, the information that I've placed on record is accurate. That Fort Ranger that I'm saying was used by Bongani Yende. Bongani Yende was also a member of the South African Police Services, my lord. And the reason why we are requesting this information, my lord, we are well aware that the state has got no obligation to assist the accused in the conduct of his defense. The state cannot get out of his way and go out and get information in favor of the accused and say, accused, this information, you can come and challenge our assertion against you therewith. But this information is different, my lord. It is information that is in the domain of the South African Police Services. There is nowhere else where we can go and request this information but from the police themselves. So we constrained because we cannot go to people and say, can you please give us this information? The only people from which this information should be received and must come from, if this information is available, are members of the South African Police Services. Which is the reason why we're requesting the state to kindly furnish us with this information if they are able. If they are not able, then they are not able, my lord. That was point number 2. Now, point number 3, my lord. Now that the state has closed its case, normally at this point in time, the defense has got options. It either says we are going to testify or we want to bring an application in terms of Section 174 of the Criminal Procedure Act. Now, we had a, when I say we, I'm speaking on behalf of accused number 1 and 3. We spoke to the Legal Aid South Africa just a second, my lord. There's something that I need to clear with my colleagues.
Just have a word with my colleague.
Thank you.
What's happening? Mr. Baloyi, have you closed your case?
Yes, indeed, my lord.
What does the law say? Once you've closed your case?
Well, once we've closed our case, then that is the turn of the defense to present